announcements not related to repossession, but related to the Bureau. This is the only topic that anyone has been talking about recently. Basically, the Bureau is something that is here, and we're going to have to address it going forward. With that, when I was over at NARS, one of the things I talked about was the Bureau was recently created last year, give or take. For the most part, the Bureau was created to deal with the student loan issues, the mortgage crisis, the credit card issues. So the Bureau, as their initial directive, was to start dealing with these issues that are out there currently. When I spoke at NARS, and before that at some other places, I said, you know what, realistically, we should be prepared for this, but I don't foresee the Bureau coming down with third-party vendor relationships as quickly within a month or two. I was wrong. What happened was, on April the 12th of 2012, the Bureau issued guidance. And the guidance they issued was directly related to managing third-party relationships. Basically, the Bureau, who's probably only issued maybe about 6 or 7 bulletins since they started, the most recent bulletin is related to them looking at and setting forth the procedures for third-party vendors to be managed by the financial institutions which use them. What that basically means, folks, is that it's here. And what I mean by it's here, it means, like I said, in the past 2 to 3 months, I've met with a good majority of the banks who we represent, credit unions, major institutions. And what we're talking about is the vendor relationship. What my expectation of them is, how they should be managing these vendor relationships with you folks, for instance. What this means is, and this is why I think this topic is very relevant to you right now, the question that always comes up during these conversations is, we'll get into the nuts and bolts of what we're going to be looking for during the presentation. But the ultimate question comes down to, what happens if our vendor, our repossession company, does not comply with what we want? What should we do? First thing I tell them, give it a little bit of time. Set forth the standards, let them know what's needed. And if they don't comply within that time period, because this is a new dynamic, what I'm telling them is they have to no longer send work to you. So when I say to you that this is something that's real and something that affects the bottom line, it does. Because when the Bureau comes in to examine the banks, the institutions must make sure that what they have is compliant. And if they have not done their due diligence in making sure you folks have all the things that they need, the recommendation is to stop giving you work. Because there is no other choice. Because the bank will get hit for the non-compliance of their vendors. So when I say it's important, that's what it's all about. And if I may just read very briefly from the bulletin that was issued. Title 10, that's where the Bureau came from, grants the Bureau supervisory and enforcement authority over supervised service providers. Supervised service providers are you folks. Under the Act, if you work for a bank, financial institution, credit union, whoever it might be, who is under the supervisory authority of the Bureau, you are also under the supervisory authority of the Bureau. So let me say that again. You are under the authority of the Bureau once you make that decision to work for one of these financial institutions that is under its examination procedures. So what do they say about that? It provides the Bureau the authority to examine and visit on-site your operations. So we've all probably in the past had the banks, the institutions come out to your place of business, check it out as the normal in the past. And guess what? The government can now come out to your site and do all those things as well. That's what this is about, folks. This is a new dynamic of what's happening out there. It's not just the banks, and the banks are going to be pushing you. They're pushing you because they know that the government as well can come to your site. And this is what happened on the April 12th Bureau. This was the first guidance that was set forth. And that guidance, as of April 12th, is saying, we, the Bureau, are going to take our enforcement authority, and we are going to use it, number one, the supervised entities of the third-party vendors, and we're going to reserve our right to come out to visit those sites. So they did not have to say that in the guidance, but they put it specifically in there. So again, I just indicate that this is a warning as to what's coming. And not to go off track for a moment, but at some of the previous conferences, I think I may have spoken a little bit too much and didn't give enough chance for folks to kind of throw in any questions. So at any point in time, feel free to interrupt me if you have any questions. Yes.
Michael, just for the information of the audience, the Bureau gives out a number as far as the size of the financial institution that the fund was their supervision.
Correct. We'll get through that, but you're absolutely correct. As we go through this, what you'll see is there's actually, number one, a cheat sheet as to these financial institutions are going to be supervised. And that's based upon how large the institution is. Then there is also other means that the Bureau is going to use to determine who is going to be supervised as well. And we'll go through that also. So when you're going through, for instance, yourselves and say, okay, these are the clients we represent. Are they under the guidance of the Bureau? Yes, they are. In which case, you know, okay, they are. That means we are. And like I said, we'll go through all that, but that's absolutely correct. Now, that's the doom and gloom part. The good part about this is, and I think most of the folks who I've spoken to here and at the other conferences, bottom line, there's some bad apples, bad actors out there. Those folks probably aren't going to make it through the procedures and policies that I'm telling the banks to go through for their vendors. And what that means is there's an opportunity for work. I mean, it means basically those folks, as I'm telling the banks to get rid of them, they have to come somewhere. And they have to come to the entities, the organizations that run well, run in compliance. So as much as there's the negative side of all the cost of compliance, and folks, there is a cost to this compliance, there's no doubt about it. It's something different outside the norm. You're going to have to get used to it within the normal course of your business. But there is that opportunity as well as a result of that. And that's just the part to keep in mind for this, that as the banks are getting rid of these folks, because they're going to have to, that if you are doing things the right way, pursuant to the way they want to, there's an opportunity for some work there. So that's kind of how it comes all full circle here. So what is the Bureau? Basically, the Bureau, I'm sorry, can everyone hear me in the back? Basically, the Bureau was created in response to the mortgage crisis. When the mortgage crisis hit, what happened? Congress got involved and said we should never have this happen again, so they passed Dodd-Frank. The Dodd-Frank Act is what created the Consumer Financial Protection Bureau. The thought behind the Bureau does make some sense. And what that thought process is we've got a lot of government institutions, the FDIC, the OCC, the FTC, all these institutions basically have some control over consumer products, consumer finances in some way. So what they said was, let's consolidate everybody together, take from all these organizations, the Credit Union Associate Administration, take from all of them their consumer aspects, and put it all into one organization, one bureau who can supervise and oversee them. So that was the thought process behind the Bureau. So that's how it was created. So the OCC, the FDIC, they've taken all their authority from the consumers, monitoring the consumers, and put it within this Bureau. So once they took all the different organizations who in some way were affected by or oversaw consumers, they then said, okay, well, what should the Bureau then oversee? And here's kind of just a synopsis of what they're talking about. The one thing that affects you guys, the Fair Debt Act. Clearly, you guys were under the Fair Debt Act before this all began. So the Fair Debt Act clearly comes within this purvey of the Bureau. Unfair trade practices, consumer protection laws, all those different types of things are also part of this as well. So what this means to you guys is that you are under the Bureau in some form once we see exactly how the market participants work. So this is how the background of the Bureau works. They took all of the organizations, took their authority away from them, put it in one organization, and then said, okay, all the things that you guys have currently been enforcing, we're going to enforce now. So what were the objectives of the Bureau? The objectives of the Bureau, and this is what you must keep in mind, the objectives of the Bureau, and I'll go through these, are related to consumers. The Bureau is all about the consumer. And that's what you have to keep in mind as we're talking about this. That's the different dynamic. That consumer complaints how the consumer is viewed, how the consumer is treated. That's what their main authority, their main directive is related to. The FDIC, the OCC, the FTC, those organizations that were overseeing the banks previously, they were concerned with it. But their concern, well, that was not the foremost concern. Their concern was equity levels, their concern was deposit levels, things along those lines. There wasn't as much focus on the consumer side. This organization is directly related to the consumer side. It's directly related to that person whose car you just repoed, and whether that person had a positive experience about the repo. That's what this is about. It's about the complaint that that person may initiate as a result of that. Whether a legitimate complaint, whether an illegitimate complaint. That's what this is about, and that's what we need to start addressing. And that's where you're going to see the pushback from the banks in doing this. So just to look at their overall message. They want to make sure the consumers have timely and understandable information. The big one, protect consumers from unfair, deceptive, and abusive acts. We'll talk more about that. That's the thing where they're going to be pushing you folks to make sure there's training and compliance, not just of yourselves, but all the people who work with you to make sure that they have training and compliance related to the FDCPA, related to unfair trade practices. Make sure what you know rolls down to the staff. Fair competition, consumer financial products. Talking about the fair competition. That actually is a positive. That's kind of what we talked about. That 30% of organizations who do it the wrong way, that does create unfair competition for you guys. It pushes down the price of what you can charge for your service because there's a shop out there who's willing to charge a whole lot less because they're cutting corners. If the Bureau does what they should be doing, and they do it well, what would happen is those 30%, hopefully, the banks will have to get rid of. And then the better folks are out there, and it's a whole separate issue as whether you're going to be able to negotiate a better price, but at least you're taking away some of the competition that was undercutting you because they weren't doing it the right way. So when they talk about promoting fair competition, that's what that's all about. The final thing which I point out, the director of the Bureau says we're also there to level the playing field. And I try and keep my politics out of it. Everyone probably has an opinion of the Bureau, not an opinion of the Bureau. But it's important to know where they're coming from. To level the playing field. I personally do not believe the playing field was unleveled to begin with. However, the Bureau is taking the position that the consumer had been treated unfairly in numerous ways in the past because of the mortgage crisis, because of the credit card crisis. Because of that, you must know where their thinking is. Their thinking is that the consumer had been treated unfairly. And whether we agree with the Bureau, whether we disagree with the Bureau, that's where they're coming from. So that means we have to change our mentalities and know, okay, we now have to make sure we are handling all customer complaints, all customer issues in a different way than before, because is it guilty before proven innocent? Who knows? But basically, that's the message being sent from the director itself as to the organization. So the next question I think someone asked me yesterday, is the Bureau going anywhere? If a different organization, if a different party takes over, are we now going to call the Bureau gone and that'll be the end of it? The answer is no. The Bureau is here and we have to deal with it. The reason I say this and the reason I put this slide up here is the Bureau's only been around for about a year. In that 1 year, they've already hired 750 folks. And there's their funding limits, 496, 547, 597. That's what their funding limits are to run their organization. And those funding limits are not going anywhere. So we can pretend it's not there, but if you do that, you do it at your own peril, because the organization is going to be there. I think in our lifetime, it was only Reagan who was able to actually get rid of a Bureau within the government. So I do not foresee anywhere in the foreseeable future that a Bureau, a complete Bureau within the government is going to be gone. They do have a discretionary $200 million funding limit from Congress each year. Maybe as times change, that funding limit might not be approved, but the approval for the budget will always be there. So when I say we have to address it, we do, because it's there. So the big question becomes, who is being supervised, and more importantly, how does it affect you folks here? And basically there's two things that are happening with supervision. direct supervision and indirect supervision. The direct supervision relates to the large banks and financial institutions. They're the folks who will actually be coming in, doing audits with the banks, doing audits with the financial institutions, sitting in their conference rooms, asking for their books and going through their books. So that's the direct folks. The indirect folks are what we talked about. Any entity who works for one of the directly supervised entities, you are now affected as well. So realistically, you guys are going to be part of it. Which takes us to, well, what is direct supervision? As we talked about earlier, banks with over $10 billion in assets are directly supervised. There's a cheat sheet for that. If you go onto the Bureau's website, it'll specifically set forth, here are the banks who are currently going to be directly supervised, and we can determine that based upon solely their assets. So for the most part, a lot of the folks you guys work for, just check the sheet, it's going to be there, and if they're over $10 billion in assets, they are directly supervised. Then it moves on to the next part. Yes, ma'am.
Okay, if I'm asking something that you're going to cover a little bit later, I'm going to be very sure. I'm talking to some of the smaller institutions, and they act like I'm speaking Greek to them. I mean, they say, what do you mean? We don't care. I mean, and I'm trying to, say, tell them how important that we are doing this, and they care less.
Exactly, and that kind of ties in directly here. You're absolutely correct. Probably a lot of those, the smaller banks, the smaller credit unions, places like that. What's happening currently, those folks are not under the direct supervision of the Bureau. What that means is that the Bureau does not apply to them. So that smaller credit union.
So how do we get it through to them?
What's going to be happening is, for that smaller credit union, that smaller bank, under this dynamic, under what a larger participant is, they're still defining what a larger participant is. So that small credit union, who might just have a credit union within a certain county, within a certain state, their assets might be 2, 3, 4 million, whatever it might be. Oddly enough, they may be considered a larger participant in a market. The market may be defined as that particular county. So to go to your question, how do you push it through? It's going to be tough. And the reason being is kind of the conversation we're having here. The smaller banks, the smaller credit unions are getting pushed more and more for more compliance they have to do. And it's that cost of compliance, hiring that compliance officer, and a lot of these folks are pushing back and saying, well, you know what? We're not directly affected. We're not going to deal with it yet. So
we should go straight to the compliance officer.
I'm sorry?
Then we should go straight to the compliance
Without
officer.
question.
Instead of the collection manager or whatever, we go to the compliance officer.
Exactly, because the compliance officer is the one, if they're doing their job, they know that they're currently not going to be affected. But this, purely a prediction, this organization is just going to get bigger. So if the standard for the larger banks and the larger institutions is one thing, ultimately that same standard is going to apply in some form to the smaller credit unions, to these other folks. It's just by nature, by implication. If you look at any of the banking laws that came out over the past 30 to 40 years, they generally apply to the larger banks. What happens over time then, those same laws, some permutation of them, then start applying to the smaller ones. Maybe not by direct statute, but by practice and policy. So ultimately, up front, they're probably not going to deal with it, a lot of them, but some will take the initiative to do so. But ultimately, the sell to you then, to them is, it's coming. Without question, it's coming. It might not be a month, 2 months. It might be a couple of years before it hits those folks, but it is going to come there. And once the industry standard gets set, if they're not following what is the new industry standard, that's what's going to happen. The best example is probably information technology and protection of social security numbers, private information folks. Initially, that wasn't applied so much to the smaller credit unions and smaller banking institutions. However, the industry practice and procedure became that became the priority of the industry. Same thing here. This is going to become the priority of the industry. And can't say for certain, but it's going to trickle down. But looking at what is a larger participant, some of you folks sitting here today may be viewed to be larger participants under the Bureau's guidance. They have not addressed repossession companies as far as who they're going to be enforcing, who they're going to be supervising, but under their definition, which is still a gray area, If you are the largest repossessor in Florida, you have many offices within Florida throwing a state out there. You are someone who affects consumers. You are someone who is a large participant within that particular market for that particular service. Can I sit here today and tell you the Bureau will not find you directly enforceable? No. There's a possibility that will occur. And the reason I bring that to your attention is that's what this Bureau is about. Their powers are not going to get smaller, they're going to expand more. So the key now is to get on top of compliance and stay on top of it, because if you are on top of it, you'll be okay. If you wait behind and wait for the curve to hit you on the back end, then for the most part, you're going to have problems with the banks you work with. And if they decide that you're going to be a direct enforcement agency, then you are going to be hit as well. So all we're talking about here is getting ahead of it. And that takes us to the next part. Are you engaging in conduct that poses risk to the consumers? And why I say that you folks might be closer to being looked at as a direct supervised agency than some other places is the knuckleheads on TV. I mention it all the time. Those knuckleheads basically set forth the example of what the repossession industry is to the folks who know nothing about the repossession industry. We talked about 750 employees of the Bureau. Of those 750 employees, obviously some of them watch TV. So they're going to watch TV, they're going to see this, they're going to say, well, is that the industry? Maybe it is, maybe it's not. But let's look at it. So that's why when I say that the perception of what you guys do, unfortunately, is guided to a degree, misguided, by what's happening on TV. And unfortunately, you're stuck with it. So knowing that you're going to be stuck with it, knowing that it's out there, you must get ahead of the curve. Because what they're looking for is, this is their language, not mine, determined as engaging or has engaged in conduct that poses risk to consumers. That's their language as to who they're going to be determined as a non-bank provider, who they will supervise. I'll just reiterate it again. Engaging in conduct that poses risk to consumers. That's how you become someone who's directly supervised by the Bureau. And clearly, what people see on TV poses a risk to the consumer. So what becomes of it, who knows? But again, it's just an awareness of what's out there. So we talked about it a little bit. What is a larger participant? Yes, sir.
Maybe I'm trying to figure out who's there to protect us. I've heard the sky is falling. I've heard the sky is falling theory. I'm used to schoolyard bully politics. But in your words, you're telling these banks, these big banks, not the small ones, the big banks, hey, if your repossessor doesn't dance to your tune, get another repossessor. Now, we just went through what happens when a big bank pushes around the repossessor. None of us in this room are foreign to having the big boys try to push us when we're the ones that do the work. JP Morgan, with their new contract, really displayed their true colors. And I have no mistake in my mind, that bank is no lot more a friend to me than they are their debtor that I'm going after to repossess. So if we got a government bureau that's there to protect consumers, because God knows they're the victim, who protects us from the big banks? Because you're telling them, listen, if your puppet doesn't dance to your tune, get another puppet. And I'm sitting here saying, whoa, 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 whoa. I see how JP Morgan Chase acts. I'm sure Bank of America, Wells Fargo, all the rest are going to dance the same tune under the disguise of safety and compliance, because those are big spin words lately, to basically run me right out of business. So that they turn all the repossessions into another nationwide par. And we can all just pack up our trucks and go home.
What I can tell you to answer your first question, who protects you? Yourself. The reason I say that is, and here, I'm not here to protect the big banks, support them against, they are clients of ours. A lot of you folks are clients of ours as well. But here's what I'm just trying to get across. The Bureau is setting the agenda. The agenda, we'll talk about it more. The agenda being set by the Bureau. In the past, years ago, we all been through it. IT, protect, we talked about it. You gotta make sure the IT is protected. You gotta make sure personal information is protected. This is the next shoe. And this is a bigger shoe than it was in the past. So by protecting yourself, what I mean by that is, I'm talking a lot here, but what this boils down to is this. Do you have a compliance manual? Do you have an employee manual? Do you update that employee manual? Do Do you tell your employees what's in the employee manual? Do you have some knowledge of the FDCPA? Other acts that affect your industry? Are you teaching that to your employees? Are you quarterly, annually, whatever it might be, having a compliance program that you can use? I spoke to some folks here yesterday and today. There's that initial setup. Get yourself set up right. Once you're set up right, then it's all about maintenance. It then becomes all about, okay, I know this is the game. Here's the rules of the game. What I'm doing here today is showing here's the rules of the game. How you decide to play the game is completely up to everyone in this room. But once you know that, once you initially get set up, all you then need to do is just to make sure you're maintaining it. Make sure, for instance, TFA, I think tomorrow you guys have a good conference set up for training, showing these different things of compliance. That certificate you get at the end of the day is something you will plaster right in your book, which you will then send it directly to the banks, and that's the value. The problem is a lot of folks aren't going through the training. They're not doing those things. And that's the new dynamic. If you choose not to do it, that's your choice. But those folks, I'm telling the bank, if they're not going to do it, you got to get rid of them, because guess what? The Bureau is going to ding you for it. So, going back to the question, it's not as onerous as it seems, but it is different from what we've seen. Once you get yourself set up the right way, then you just have to make it part of your business model, part of your business practice. You know what? It's a pain in the butt. I got to do the Fair Debt Act collections updates. I got to do this update. But once you make it part of the routine, you'll be good to go. Once you start training your employees each time of it, they can sign a piece of paper that yes, we went through the Fair Debt training, yes, we went through this training, plug it into the file, you're good to go. Is it a cost of compliance? Yeah, it is. Can I tell you the banks are going to raise the rates or what they're going to probably ask you for your repos? Probably not. But to be part of what this is, that's what it is. So, don't know if I necessarily answered your question, but basically it's going to fall on you guys to make the determination that if I want to work for one of these banks that is being supervised by the Bureau, here's the rules of the game, and I have to abide by these rules of the game. And like I said, it's not as onerous as they seem. But it's different. And just talking about the larger participants, we kind of talked about it briefly, whether you folks may be determined to be a larger participant. That's the next thing. The government is now involved in this on a daily basis, where a year ago they were not. That's where the game changer comes from. In the past, when you were dealing with the larger banks, it was their internal policy that they would be setting, saying, you know what, I can work with this repossession company because of reputation, the years we've worked with them, the knowledge, the area, that makes them of great value to us. And they'd be able to overlook certain things. That's the reality. That's the reality of the business. That reality is now gone because now the government is looking over them, and those things they might make a decision, you know what, from a cost of doing business perspective, I want to keep these folks because I've worked with them for 30 years. Maybe they don't have the best employee manual. Maybe they're not doing the FDCPA training. But you know what? I'm not getting complaints from them. I'm getting great results. I'm going to keep them. That's where this dynamic changes. The government is now saying, here's what you require. And that's basically a game changer. Going through that with the government, so who is the larger participant? We talked about it. Using Florida as an example, California, whatever state it might be. If you're the only repossessor in Rhode Island, you are probably the market maker. As the market maker, you may be determined to be directly supervised. If you're directly supervised, like I said, that's a game changer for you. That means the government comes in and audits you, does all those different things. That's months, probably years down the road, hopefully. Because the government has not, the Bureau has not defined what a larger participant or in a market is. That is something still in flux because the organization is new. So realistically, whether you guys will be considered a directly supervised entity, it's probably not something for you guys to directly worry about now, only in the sense that if you work for a directly supervised entity, you basically are being supervised. What you folks really need to worry about or look at and deal with is the indirect supervision. And basically, just to go back to why we're here, this is the manual of the government. This is not the bank's policies. This is the government, the Bureau. This is from their supervision and examination manual. Basically, this is their rule book. Their rule book is 800 pages long, actually 842 pages. So when the bank gets it, they have to deal with a compliance program set up according to that new rule book. And what I've done is I've taken some things in the rule book here to let you know this is what we're dealing with and where it's coming from. The rule book basically says that the third-party service providers, you folks, you have to ensure that you're compliant with federal consumer laws, applicable products being provided. Again, it goes back to, are you set up with a policy procedure manual? Are you set up with an employee handbook? Did your employees sign that handbook? Did they sign that manual? Did they acknowledge they've read it, they've received it? Are you continuing with your training of compliance laws? Are you continuing with your training of these things? I get it. I'm being recorded, so I'll choose my words carefully here. Pain in the butt. I get it. But at the same token, that's what it is here, folks. If you're not doing it, if you don't have those certificates, guess what? Your competitor may be doing it. And if he is doing it, the bank's going to basically say, I'm going with that person because this person's not complying, because Dougherty's told me I can't go with someone who doesn't have this. That's what it boils down to. It's not me telling them. It's me telling them through the Bureau. And then basically, this is the big thing here. They expect every regulated entity under supervision and enforcement to have effective compliance management. What that means is they expect you folks to have the same compliance procedures as the bank itself. That's a tall order. These multi-billion-dollar banks have hundreds of folks in their compliance departments who set forth a million different things for you folks having to oversee, comply with. The expectation, again, of the Bureau is that if the bank makes a decision to subcontract out a service that they provide, repossession, for ourselves, I'm speaking from experience, I'm in the same boat as you folks, on two regards. Our law firm is going to be directly supervised by the Bureau. In addition, we are also being indirectly supervised because those same banks that you folks deal with, we deal with them as well. So basically, we are having to do the same thing you folks are doing. For the past few months, all we've done in our firm as well is sit down and talk about compliance. Do we have our manuals there? Do we have these things? Because when I say it affects you, it affects any industry that basically is a subcontract to the banks. So we're in the same boat as you folks to an even more degree because we'll be directly supervised. And what they require is if the guidance of the bank is to do it a certain way, you need to do it a certain way. In a smaller shop, that's tough. That's expensive. There's no doubt about it. But there are ways to go about setting it up so you can still work within what is required. And again, I'm beating the drum here. You need to have that initial setup with the compliance manuals. And then you just need to make sure you take advantage, for instance, what TFA is offering. They're offering the compliance training. Once a year you come and you get the training done, whether it be through TFA, whether it be through another organization, whatever it might be, but you must make that part of your routine within the business. If you don't want to work for any of these folks, then you can just ignore all this. But if you want to work for these folks, you can. And here's where the change is even more so. Everybody here deals with their vendor manager, whoever it might be. We all know who the names of them are. This is not being pushed by those folks. And what I mean by that is, the Bureau has said compliance of third-party vendors has to start at the senior level at the board of directors. So again, we're talking about these larger, multi-billion-dollar firms, international firms. The board of directors of those firms, where repossession is a very, very minuscule piece. From my perspective, our law firm, we do a lot of collections work. Where our collections work is a very, very small piece. Guess what? Those small pieces are now on the agenda of the board. That's huge, folks. For the fact of working third-party relationships, this is coming from the board of directors, from the very top, because what happens, those are the folks who the Bureau has said are going to be ultimately responsible. So when your vendor management is pushing this down on you, guess what? They've been pushed down on from probably 7 to 8 levels above them. So this is something that's failing to be done.
So what's the penalty?
The penalties are numerous. There are civil penalties, there's enforcement penalties, there's ratings. What I mean by that is civil penalties, monetary penalties. If the bank or the institution or the supervised entity does not comply, ultimately, and this is down the road, but one of the penalties is cease and desist orders. So these are the types of things. They start with for lack of better terminology, the slap on the wrist, meaning, okay, here's where your issues are, fix them. You don't fix those issues, it gets ramped up. Okay, you haven't fixed it, monetary penalty. Haven't fixed it again, more of a monetary penalty. Still haven't fixed it, cease and desist. I'm sorry?
How does that amount? I mean, is it like you're talking about it's $10 million?
It's still,
I mean,
it's still
how is
being,
the monetary penalty? I mean, if I'm calling a client and trying to really push this through, how do I tell them, okay, this is gonna happen to you, you're not paying attention to what I'm saying?
basically what's happening is numerous different ways. To give you the best direct answers they can. They can do it based upon assets, they can do it based upon just fines, so it can be as little as a few thousand, it can be a percentage of their assets. So there is no set guidance for that. Under the Act, they have the right to do all these things, whether it be a smaller monetary fine to a larger monetary fine. So to give a direct answer, I don't know at this point because they haven't issued any yet because they're new. Under the Act,
When you say to cease and desist,
that's if you completely ignore it, don't do it, don't do what they're supposed to. They can hop in there and say, you know what, you're a bad actor, you're out of this. That's how.
shut them down, shut them right down.
Shut them down, slow them down, whatever it might be. They do have the right to basically enter an injunctive order, say you need to stop and fix it. So that's how serious we're talking about it. And again, that's many steps down the road, and I can't foresee any bank or institution even getting that far. But there will be instances where if you have 250, 270 vendors in the repossession industry, and they come into your office, the banks, look through all the manuals, and you know what? 20% of these folks aren't compliant. You have 30 days to get compliance. 30 days goes by, you're not compliant. What happens then? Okay, monetary fine happens. Guess what? That vendor manager at that bank, they're not going to be too happy because their head's going to be on the line. So that's why I say this starts at the board of directors, and I can pretty much guarantee you that the vendor manager is not going to put their neck on the line when this guidance is coming from the top. Yes, sir.
Michael, speaking of penalties, on your third slide, you showed that part of the consolidation, FDIC was one of the agencies consolidated. This lawsuit that got filed late last week, maybe early this week, where the FDIC sued 5 banks, is that part of this new bureau?
It is not. But those organizations, the FDIC, the FCC, all those different places, FTC, what happens is those organizations are still there. What they've done is they've taken from those organizations any of their authority related to consumer protection matters. So the FDIC is still there overseeing the banks on a million other issues, but as far as the consumer side of it, that's what got pulled away from all these organizations. So it's just the consumer part of each organization that got pulled away.
Thank you.
Yes, sir.
So the forwarding companies, the large forwarding volumes, are going to fall under direct supervision because of the massive amount of possessions they're getting.
Potentially. Actually, it took a little bit longer for me to hear the word 40 than I thought.
Well, I mean,
no, I agree.
but what you described is that.
Yeah, without question. Those folks, that dynamic's going to change as well, for the most part, because they very well could be directly supervised, I agree, but they definitely are going to be indirectly supervised, just like you folks.
So if there's a small credit union having them work, from a small credit union in Alabama, and I call up XYZ forwarding company to do this work, and they send it to somebody, is the small credit union going to be under more direct supervision because of who they're using?
Potentially. In that situation, if you have the small credit union who's using a larger forwarding agency, the credit union in that instance will not fall under direct supervision because they're not actually subcontracting, they're not subcontracting their own service. The distinction is kind of one of the legal ones in the sense that they're the initiator of the action as opposed to the one following through the action.
But it put them under more indirect supervision, wouldn't it?
Probably not under that scenario through forward. Ultimately, like I said, they could be once they determine what a market participant is, but for them, the smaller credit unions sending work to the forwarder to be sent out, that will not put them under the direct supervision. It's certainly going to put the forwarder there.
How would they know? How would they know that the small credit unions are using this big forwarder that uses all the jackknife running around?
Basically, what's going to happen is once they make a determination that, say, for instance, one of the larger banks is using that forwarder, So that forwarder now must make sure they're complying with the bank's regs. So what that means, if the government goes in, conducts their audit, they're going to say, okay, to the forwarder, who are you working with? Who are you using? Do you have the manuals from those folks? Do you have the compliance information from those folks? So what's going to happen is once the bank gets audited, they'll look to the forwarder and say, okay, you're using this forwarder. That forwarder better have all that information.
On every one of the vendors.
My recommendation to them would be absolutely 100%. My recommendation to the bank would be, if you're using the forwarder, and this is what my recommendation has been, if you're using them, that is not a means to shirk what your ultimate responsibility is. You can use them if you want, but you must make sure that if they're using 1,000 different agencies for the repossession because they're national, whatever it might be, you need to make sure they have all the compliance information that I'm asking of you bank, I'm asking you guys here, and then they must then internally have their own compliance, and they can go from there. So basically, the board becomes a third-party holder of the information. You better believe they're required to, because I'm telling them that.
So a recovery company, if they send forms to that contract, like whoever, they can't just send out contracts, you will be in compliance, let them sign off on that. They can't escape that procedure. They have to make sure and verify themselves. It's just, well, here he signed off, said he's in compliance. They can't get off the hook that way, correct?
Correct. That's the days of yesterday. The days of yesterday were, hey, are you compliant? Yep, yes I am. I certify I'm compliant. Here's my signature. That day is gone. Whether you're a forwarder, repossession, the agency itself, the bank, anyone in the chain from the bank all the way down, you must have all this, everything I'm talking about now, forwarders are responsible to have as well, without question.
Is this the same department that Richard Corday is in charge of?
100%. This is the department that was created by Elizabeth Warren, running for Senate out in Massachusetts. That's that department.
So he's already been to battle with the big ones anyway, like Bank of America.
He's preliminarily seen just about all the banks. They have not started their audit yet. What they've been doing is they, for lack of a better term, they're making the roadshow. They're going around to the banks. They're going around to potential larger market participants and saying, okay, guys, here's what we're doing. Here's what we're going to be looking for. Here's the guidance we're going to be giving. So yeah, absolutely, they've already started that process. The enforcement part of it, the actual audit process, the anticipation is from the guidance we've gotten from them, third quarter, fourth quarter this year, maybe into next year. But right now, they're going out and telling all the banks, here's what we're requiring. Absolutely.
So is there a process where we can report them?
Report the bank? That's a business decision. So,
Do you have a department or someone on staff, or is there someone on staff that if we know they're not using compliant agents, that we can report?
we'll go through, that would be basically considered what's called a customer to a degree complaint. I mean, a whole complaint procedure which we'll go through. But again, that's a business decision that we'll make a recommendation on one way or the other. That one I'm going to stay away from. But, so like I said, this is coming from the top. So when you hear your your vendor manager pushing you and pushing you, this is the reason why. It's coming from many levels above their head. So talking more about the indirect supervision, which we're talking about, again, this is from their manual. When I talk about the policies and procedures, it's not just me making this stuff up as I go along. Everything I'm taking is from the manual. The examiners, that means the Bureau, when they're in there, should request and review compliance policies and procedures. So basically, when that examination officer is in there, he's going to be asking for the policies and procedures. Review the policies and procedures designed to ensure that these third-party service providers comply with the legal obligations. Again, it's not just me making it up. This is the Bureau's handbook. This is the rules of the game, as we like to say. These are the rules. The supervision and examination manual. When that supervisor, examiner, walks into the bank's conference room and plops down that 842-page document, these are the things they're going to be looking towards. They're going to be looking towards, show me the policies and procedures of your 250 repossession vendors. Sit down with me, I might randomly pull 10 of them. Give me these 10. Pull out the file on the computers nowadays, pull it off the computer, whatever it might be. Okay, show me what they're got. Where's the compliance manual? Where's the employee handbook? Where is the certification that they're complying with fair debt? Where is the certification that they're complying with unfair trade practices? Show me that file, show me that information. So when you're getting those requests, which you will, for that information, this is the why. So part of what I'm just trying to do here today is just to kind of tell you why are the things that you're going to be seeing in the next few months are happening. You're probably going to start seeing, if you haven't already started seeing, a lot more site visits. They're coming as well. One of the things we talked about, and they've already started, is do we need to visit all the different providers? My answer to them is yes. Do you have to do it every year? Preferably yes, but if you can't make it every year, understandable. But part of your practice now must be to visit every service provider and go through with them if they have all this documentation. So that's what the new dynamic is. So the question, okay, now how do they determine risk management? How are they going to supervise? How are they going to do what they do? Because the Bureau is new, they haven't set forth their own particular guidance on how they are going to do it. What they've done is, though, they've adopted the FDIC guidance on risk management. So what they've taken is the playbook within the playbook. They're saying, okay, the FDIC guidance is what we're going to use. And how does the FDIC manage risk, or how do they expect the banks to manage risk? They look to 4 things: risk assessment, due diligence, contract structuring, and oversight. So that's what they're looking for. So breaking it down. The risk assessment, that falls on banks. That is going to be a bank issue. The bank must make a determination early on. Do we want to subcontract this service? If the answer is yes, we want to subcontract or repossession. Okay, yes we do. We can't handle it internally, so we want to subcontract it out. Once that determination is made, the bank cannot then say, okay, let them handle it. They must have knowledge of how the industry works that they're asking it to subcontract out to. And I've mentioned this at every conference, at every place I've been. Huge marketing opportunity for the associations, for the conferences. The reason being is the banks are required to know what happens in the industry. What better place to get that information than being a member of the TFA, or an organization that they can say to the bank, because they can say to the Bureau, hey guys, we go to TFA meetings, we're part of what they do, we listen to the feedback we're getting from the companies who are under those. So from a marketing perspective, the banks are going to have to get involved in these things, and the organization should absolutely market to them, hey, this is a way to help your risk assessment because it shows that you are actively involved in the industry and you're not just kind of sitting from the side. So it's just a great opportunity there. Which moves into the due diligence. Once the decision is made to subcontract out service, repossession service, in the past what it was, what's the reputation? What's their experience? What's their knowledge? Those are the factors. Hey, these are good folks. We've dealt with them 20, 30 years. These are people we've been working with, no issue. They were the things that due diligence in the past. Now the due diligence is much more. And some of you folks have probably already started to see it. Financial records. They're going to delve more deeply into your financial records. The reason being, it goes back to that promoting fair competition. The Bureau is not going to want companies hired who are in a bad financial situation. The logic behind it is they'd be more inclined to cut corners. So when they're asking for the financial records, that's the reason why. Because the Bureau, that's the logic behind it is if it's a financial issue, there's more of a likelihood of cutting corners. Would that be dispositive of you not getting work or getting work? No, it will not. But it's a factor to be considered. Experience, which has always been there. Here's the other big one. Knowledge about applicable laws and regulations. In the past, it's been a big deal. Here's our certification, here's our bond, here's our information. We've now complied. This is the game changer to a degree. They're going to want to make sure, do you have a procedure in place for training, upkeeping that training, FDCPA, unfair trade practices, anything that affects the consumer, what do you have in effect to show us that you have compliance for that? Reputation, effectiveness, operations, information systems, that hasn't changed. That's the same dynamic as it's always been. And there it is again, knowledge of the consumer protection laws. Realistically, that was in the contracts in the past, and for the most part, it was probably one sentence within the entire contract, which is kind of an in-passing sentence. Now I can guarantee you, you've got the most recent contracts from a lot of folks that came out, I can guarantee you within the next 2 to 6 months, additional contracts will be coming out, and you're going to see a section on consumer protection laws that have not been there in the past, or not as detailed as in the past. Because now this is something that is specifically under the guidance. And again, tying it all together, what will the contract include? Most of the information in the contract will remain the same to a degree. You're going to see a lot of it there because it's always been addressed all the different types of auditing, reporting, performance standards. But the one thing that is going to be there now that you haven't seen before is what is your consumer complaint provision? How do you handle it? How are consumer complaints handled? And again, this ties all the way back to what this agency is. It's the Consumer Financial Protection Bureau. And this is one of the big things about it. You need to now establish a customer complaint procedure. I would say most folks, ourselves included, as a law firm, we get a complaint, we deal with it over the phone, we address it, we move on to the next one. That's no longer sufficient. Whether that complaint is founded, unfounded, you must have a process in place. And what I mean by that is it's going to be twofold. The complaints are becoming in two directions. Complaints are going to be coming directly from the bank through the bureau. It's going to roll down, which we'll go through. Then you'll also have the normal complaints. Guy comes into your shop, gal comes into the shop, complaining about whatever it might be. In the past, you handle it all the time like we would. Okay, we talked to them, we figured it out, we got it resolved. Not good enough. What is your procedure? What is your form? What form are you filling out for that complaint? John Doe, consumer, comes in on what day, fill it out. What's his complaint? Fill it out. How did you handle it? Fill it out. Some of the banks are going to require that you fax, email, or get that consumer complaint to them once it's received. Within the new contracts, that's the things they're talking about as far as how the consumer complaints are going to be handled. Are you going to be keeping them on site? Or are they expecting a copy for themselves? So that's there. So what I would submit that as you're thinking about how you're going to handle these things, make sure you address this because it seems like the smallest part of this, but it's actually the biggest because that's what this bureau is about. It's about the consumers. So what happens is if that consumer complains for whatever reason it might be, because we'll take it back, odds are, if they came into your shop to complain about something, once the Bureau begins their marketing campaign to get out who they are, what they do, in all probability, in the past that person would go to the AG's office, make a complaint there, Better Business Bureau, make a complaint there. Now what they're going to do, they're going to call the Bureau, write the Bureau, email the Bureau, and say, yeah, I showed up at the shop on January 1st and made this complaint. Goes up to the bank down to you. If you don't have anything in your office indicating that person was in your office on January 1st, that's an issue. So what I'm saying to you is, this is the types of things, and this is the why we do that. The why is related to protect your own butt scoring. Even if the complaint is completely meritless, you want to make sure you have a policy that you're dealing with. Because in addition, if you have a policy on how to deal with it, if that person makes the complaint and comes back down to you, hey, where's the complaint? Well, we don't have a complaint, but that's okay, because we have a policy in place, and here's the policy we utilize. So guess what? That person's probably full of it, because we have a policy in place that we are enforcing. If you don't have the policy in place, the onus is going to be on you. The presumption of guilt. If you have the policy in place, it's the presumption of innocence. So that's what it boils down to. And the oversight. This is what we talked about. You're going to be seeing more site visits. You're going to be seeing more annual, biannual, whatever it might be, looks at what you're doing, how you're doing it. There's probably already starting to see. You're going to have more contact with your vendor managers than in the past. And that's because that's what's required in the FDIC office. So we talked about the complaint procedure on the end of the person who comes into your shop. The complaint procedure on the other end, how's that going to work? So basically, how does the consumer complain? Well, first of all, I've mentioned this and everyone drives me crazy for whatever it's worth. Their consumer bureau is set up for complaints to be taken in 191 languages. A lot of experience in this room right here. Every contract I've ever seen related to a repossession, related to a retail installment note, lease agreement is always in English. So I have no idea why it's 191 languages. Side gripe, I'll move on. So how does it work? You have this infrastructure set up. The person who has a complaint, by email, by fax, by phone call, by mail, any means of communication that you can think of, the Bureau is set up to take that complaint. So the Bureau is functioning so that it can take complaints. Once that complaint is then received, it's then sent to the company or the supervised entity, whether it be the financial institution, the bank, the credit union, whoever it is. When the act initially came out, the turnaround time to respond to this was 10 days. The lobbyist fought for that, and they were at least able to get to 15, which is still not much. And this is what I talk about. You need a good consumer complaint process. The reason being is, January 1st, the complaint comes in to the Bureau. It gets sent to the bank, to now the new compliance department who handles these things. They then have to get it out to whoever the complaint is in reference to, so it's one of your companies. They then send it to you. You then must fill it out, address it, send it back to the bank. The bank then must put it in the format required, send it back up. All of this must be done within 15 days to be compliant. And I can pretty much guarantee you that the lag time that is needed on either end of this is not going to be with you folks. What I mean is, if they're going to err on the side of, hey, we got to get this done, that means your timeline's going to be tighter. So that's just the nature of the beast. It's the nature of the beast. When we're getting complaints now, that, you know what, let's not give the 3 to 5 days to you folks to get the complaint done. We'd rather preserve that timeline on our side. So you're probably going to see 1 to 2 days turnaround time when you get these complaints. So you need that procedure.
Just a quick question. Are the banks going to be requiring this complaint process from the auction houses too? I mean, there's a number of vehicles that go to the auction that the debtors end up redeeming from them. So are these same requirements going to be upon their shoulders?
Absolutely. It's the exact same. Any organization used by the bank, in any capacity whatsoever, any service being subcontracted out for whatever reason, they are going to be part of what's considered a supervised entity.
You get there the 15 days without complaint, get it all, everybody get it and all that stuff and get it done. I mean, what if there isn't a satisfactory answer?
It depends upon what's meant by satisfactory answer, in the sense that person never came into complaint, first we're hearing.
No, the guy said the transmission was burned up by the repossessor and the repossessor didn't burn it up, period.
That would be the response. The key is making sure you get the response, and then what happens is the Bureau, and this is where the Bureau is still, we don't know where they're falling on these things because it's new. That response comes back. Number one, you're going to see, okay, are the banks going to need to be overly cautious in dealing with the complaints? And if they're being overly cautious, who's the cost of that going to fall to as far as that transmission example? Is that going to fall there? Are the banks going to say, you know what? These are complaints we've received in the past and we know they're without merit. You know what's there? That's the thing I don't have an answer for, but ultimately the Bureau is going to want some disposition. And that ultimately is going to come to the bank and say, you know what? I support my repossession company for this reason. And that's why if you're doing all these other things, it makes it easier to support. But do I have an answer for who's it ultimately